There have been so many motions lately about venue. It's like the law of real estate has become the law of the legal system as well. This is Legal Updates with Cassidy. Location, location, location. An update on all things Murdaugh. Welcome. Just after my last update premiered, I took a peek and found that Cory had filed a 9-page response with exhibits to the motion for summary judgment. On the 19th, the court responded. The 4-page order gives some good detail, so we'll just consider that today rather than going through all of Cory's response. It gives the background in the introduction, so if you missed the last update, Nautilus is the insurance company that paid out the most to Gloria Satterfield's estate. Once it was discovered that Alex, with the alleged help from Cory and Chad Westendorf of Palmetto State Bank, had stolen the entire claim, signed off by Judge Carmen Mullen, they brought this suit against Alex, Cory, Cory's law firm Moss & Kuhn, Chad Westendorf, and Palmetto State Bank. In the preceding file, Nautilus asked for summary judgment against Cory, which is basically telling the court, hey, we have indisputable evidence here, there's no need to go on with the trial, or at least with this defendant in this trial if there are multiple defendants, because there's no way they can deny these accusations. Their reasoning was because Cory had already confessed to crimes during his federal and state plea hearings, and also had gone before the South Carolina Supreme Court when he lost his law license. So Nautilus had concluded that because he admitted to cashing this check, that in fact he had gone against the insurance company's conditions for the payout check. So what were these conditions? They were given in a letter that accompanied the check, and they stated that the check was supposed to be held in trust until an order approving the settlement was filed, and we'll look at what those look like. So that brings up, were these conditions an actual contract that they can hold him to or not? Now, the paperwork definitely gets a little funny in this part of the case. I'm not going to lie, when I started looking for this letter, I went down the rabbit hole that is the Nautilus case. And this case is just so unbelievable. And I can't wait to get to this portion of the Murdaugh Mafia series because you cannot believe the documentation affiliated with these thefts. These guys were so very bold. The stuff they did is just literally out there on paper, like they never expected anyone to look into it or question them. At one point, we do see a paralegal question the request to appoint Chad as Gloria's PR. She's given a reply that she knows is not right and just kind of answers, well, I guess, but no one else questions anything. Here we have the letter in question. We can see it was dated April 22nd, 2019. It's addressed to Cory at the law firm. It tells him that the check is enclosed, the amount $3,800,000, that it's payable to Chad, who's the personal representative. And here's the instructions that they talked about. It says, please hold these settlement funds in trust until the petition and order approving settlement have been signed and filed at the probate court settlement hearing. So Nautilus puts forth that this letter created that contract, like I said, and that Cory breached this contract by not following these instructions. And based on this, he, and by extension his law firm, show that there's no genuine dispute as to any material fact, and that's the basis of them requesting summary judgment. Now, Judge Gergel gives us a wonderful little lesson on summary judgment. He identifies the requirement and also defines some of the terms that are used in the requirement, such as genuine and material. He says that it's appropriate if a party shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. He defines a genuine dispute is one where the evidence offered is such that a reasonable jury might return a verdict for the non-movement. And then a fact is material if proof of its existence or non-existence would affect the disposition of the case under applicable law. Summary judgment should be granted only when it's clear that there is no dispute concerning either the facts of the controversy or the inferences to be drawn from these facts. So, there really can't be any doubt in order for summary judgment to be granted. It goes on saying that in determining whether a genuine issue has been raised, the court must construe all inferences and ambiguities in favor of the non-moving party. In discussion, we see the reasons for his decision. He says while the movant, which in this case is Nautilus, bears the burden of demonstrating that there's no genuine issue of material, his lesson goes on that after the motion, the non-moving party, or Cory, gets their chance to dispute the claim with specific material facts. So that's what Cory did in his motion to oppose this summary judgment. And what the court makes of this is that Cory never admitted anything about this letter or any agreement that it may have formed. It also refers to the evidence that Nautilus included in their motion, which was a transcript. And the judge finds that the transcript doesn't really mention this point. And I would have to agree with him on that. And he goes on to say that a genuine dispute of material fact persists as to whether Fleming's conduct amounted to an acceptance of an offer set out in that April 22, 2019 letter, or alternatively, whether Nautilus' request amounted to a unilateral or non-binding attempt to alter the settlement agreement's conditions. So it's not a question of what Cory did. He did submit that check to Chad. There's no question about that. But he does deny this motion for summary judgment because it's not an indisputable fact that that letter by itself was a contract that Cory broke. Now, of great importance is that this ruling is not saying that Cory is not guilty. This is a judge following the letter of the law, and we have to remember that. Also, this is Judge Gergel, the same judge whose conviction against Russell Laffitte was just overturned due to his handling of the dismissal of 2 sick jurors. He's going to be double-checking everything in this case. We also just recently considered Alex's appeal where they found fault with the state, with Judge Newman, with the jurors, with the clerk, basically everything but their client. So making sure to make the correct procedural decisions is really important in stopping the inevitable appeals if Nautilus wins. But I say fear not. And also, let them win this fight over the summary judgment motion and come to fight this in court. Nautilus has every scrap of paper that ever existed in not only this case regarding Gloria, but they also have stuff about the Pinckney family, Malik Williams. They have depositions from so many people from the bank, judges. It truly is the Murdaugh Holy Grail, evidence-wise. This is just a minor win for Cory, who would have done better to plea in my opinion, because when a jury finally gets to hear about Cory's involvement, which hasn't happened yet, because he pleaded guilty to both federal and state, but this time his law firm is being put up as well. They are also defendants, so I'm sure that's why he's fighting it through this time. But when a jury sees and hears these exhibits, it's game over really, in my opinion. They will easily connect A to B. I mean, just for example with this check. When a check comes with instructions, even we understand they should be followed. How did a lawyer just disregard that? The jury's going to wonder about that. And then they'll see this, for example. In the letter, what Cory was told to wait for was the petition and the order for approval of the wrongful death settlement. So let's take a look at those in this case. And what we're going to do first is compare some documents to show you what the jury is going to see. These are those documents that were supposed to be filed in court before the check could be cashed. Now, this first one is not about this settlement, but I'm using this one to show the difference. Alex had 2 insurance companies, and he won claims from both of them. The smaller one, which is still huge, it's $500,000, came from Lloyd's London, and it came earlier than the other one. The things I want you to notice on here is look at what's called the caption. Captions are generally what we call adversarial. That means, like in this case, it says Chad Westendorf versus Richard A. Murdaugh. And then to the right is the name of what this document is. And all the way to the right, running up and down the side, is the stamp showing you when and where this was filed. So it was filed on December 19th, 2018. Now, a few months later is when this big check comes, this Nautilus check. We see some correspondence took place between Cory and Nautilus, not Alex. And this is John Grantland again, the same one who issued the letter with the check. And this is almost a month before he sends the check. This is March 25th, and he's replying to Cory. He says, "My office will work on the court approval documents as soon as possible." So we know Cory has asked him to do this. "The agreements we prepare will all have," and he has in quotes because he's quoting what Cory has asked him to put, "in re Gloria Satterfield," in the caption. So this is one important part. Cory has asked him to take away that adversarial caption. Now it's just about Gloria Satterfield. Doesn't even say her estate. But the second part's important. He says, Cory, if you want to structure some of the proceeds of the settlement, please let me know. Because why? I will be happy to put the PR in touch with the structured settlement broker. Now, why is this important? This is the kind of check in the kind of situation that you will usually structure, especially in a case like this where one of Gloria's sons has the status of vulnerable adult. So in the case of minors or a vulnerable adult or someone who needs continued care, structuring is the way to go to ensure that that person can be cared for throughout their lifespan and not all just given at once with the possibility it could all be spent. So this guy knows how that works. Now, I covered this a couple of years ago, but it's come up a few times in different hearings, and even in Alex's murder trial when Michael Gunn testified. In order to structure a settlement, the check absolutely cannot come to the attorney or to the personal representative. It has to be set up through a structured settlement broker, like Michael Gunn at Forge. And if you'll remember, when Alex was first trying out his fake Forge, he used Michael Gunn's actual name, and then he got bolder and didn't bother with it again. But if a check comes to anyone like the personal representative or the lawyer, it has to be sent back, destroyed, and done over. And that's exactly what Michael Gunn said during his testimony. Mr. Grantland knows this. That's why he offered to put the personal representative or Chad in touch with the broker. Alex knows it. Cory knows it. They all know it. But instead of saying, yes, we do want to structure this, can you let me know who I should put Chad in contact with? Cory does not request this help. And now we see this new caption as per Cory's order. Not only is there no adversarial caption, there's no mention of Alex, there's no mention of an estate. It just has her name. This could be anything. And if you look on the right, where in the other one there was the court stamp to show that it had been filed, there's nothing. Now that was the petition. There needs to be a second one. First there's the petition, and then there must be the order approving the settlement. Now the petition, as far as I know, there was never one found that was signed by the judge. But the order was signed by Carmen Mullen, but it was never filed. As you can see, there's no court stamp. So how did they go about getting Judge Carmen Mullen's signature? We learned this information in Chad Westendorf's deposition. So we learned there were the two settlement hearings, one for the petition, one for the order. December 19th was the first one, and then May 13th, 2019. This first hearing is Cory, Alex, Judge Mullen, and a clerk. Because for any official business, there's supposed to be a clerk there recording it with a record of what was said, what was decided, what happened. And of course, Chad was present for all of this. Alex's attorney should have been there. He was not. And Cory and Alex are supposed to be on opposite sides of this case, but they're there in a united front. Just three old law school classmates together in judges' chambers. Now the second one, Alex isn't there. The second one is Chad, Cory, and the judge. And this time there's no clerk. There is no official record of this hearing taking place anywhere. When asked what went on, he said there was some personal talk, that he could tell that they were acquaintances, and that he hears the word Forge for the first time. They said they're sending the money for the boys to Forge. Chad didn't know what Forge was, which is understandable. He's a banker, not an attorney. And so he asked what it was, and they told him it was an annuity investor or a structured settlement. Now, when asked if Judge Mullen approved that there was going to be a structure to Forge, Chad was not aware of any, but he did say the discussion happened in front of her. The name Forge was even said out loud. Now, in this deposition, and this is Eric Bland deposing him this day, he asks him, did you ever find out that the reason they wanted to take the caption off was because Alex didn't want Mark Tinsley, who was representing Mallory Beach, to find out he was settling a case and paying a lot of money? Did you ever hear that? And he says he heard that at the second settlement conference. The only people there, besides Chad, were Cory and Judge Mullen. So if this conversation was being had, it was literally being had between the two of them. So Cory was the one who told this to the judge. The judge replies, I understand. Just to clear it up for sure, he asks him again. This was not on court record and it was not in a courtroom. And he said, no, it was in a room off of there. Eric asks him, did you think it was funny when Judge Mullen said we're going to change the caption and take Alex's name off? But he responds that he didn't know it happened until Eric just told him. He says that Cory then says that Alex's attorneys would appreciate it if they wouldn't file the order at this time. So it's Cory, not Alex, that asks for this not to be filed, knowing that the instructions for the check say these two documents need to be filed, and then the check can be distributed. So the judge signed it knowing it wasn't going to be filed right away, at least. And then Mr. Bland lets him know it was never filed. So this is just one of many pieces of evidence, though it's a huge piece of evidence, that Cory himself was involved in accepting this settlement, knowing full well that this process was far from standard. He was not a brand new attorney. He had to have known that this was not okay. So there's no need for this summary judgment. There's plenty to prove him guilty at trial. And personally, I don't think it's a bad thing that all of this will take place on the record instead of just concluding in a motion or a plea hearing. Because I think the world hasn't focused on Cory and Russell, or Palmetto State Bank for that matter, nearly enough. And they all caused harm to all of the victims just like Alex did. Let it be known. The day of Cory's plea hearing in state court, the courtroom was half filled with people there to support him, to say what a wonderful man he was. People from church, people from everywhere. This man was responsible for harm. He and Russell and the bank and Chad. Chad may have done a lot of what he did in ignorance, but when you're asked to do something like that and get paid $30,000, which is another thing that the judge looked the other way on, his fee should have been like $2,500. She should have looked at that paper and said $30,000 to be a personal representative, but she didn't. She just signed it. And all of that will come out. The only sad part is that it won't be televised for everyone to see. Now, speaking of Russell, we have an updated status report for his new federal trial. The last update was his attorney Mark Moore requesting some of his so-called untainted money to be released to pay attorney's fees. So a hearing was held on that. But as I said, it was held in camera and not in a courtroom, and it is sealed. So we have very little information on that other than what we see here, that a potential agreement to unfreeze certain assets was begun, and he can use this money for fees and expenses for his appeal and also his upcoming new trial. That's being worked out right now. We have no details on it. And once it's completely worked out, it's going to be presented to Judge Taylor, who will sign off on that. And once that's done, those details will be shared at the next conference, which will also be sealed and on camera, not in person. And that will be on January the 2nd at 3 o'clock. Last but not least, we have an update that doesn't feel like an update because this case is stuck on a merry-go-round fighting over venue. These documents blur together, especially since there are so many defendants and we hear from multiple attorneys. And as we've seen so far and could never have guessed in a million years, is that this whole entire battle centers on one man, local reporter Michael DeWitt. And it's about what he said on a documentary. Now, he was not the origin of these rumors or the person who said the worst things. So why is it so focused on him? Because he's the only defendant who is a Hampton County resident. Now, we just saw Austin Stanley win the battle over venue in his lawsuit because publication has been deemed by higher courts to mean where the defamation is felt. And that's where people know you. And where the reputation needs repair because, again, that's where people know you. So it's where you lived when the damage was done. We also learned from that case that if more than one venue is proper, that it's the plaintiff's choice. And that would be Buster. So keeping DeWitt in this suit is imperative for Buster to get it back to Hampton. And getting DeWitt out of the suit is imperative for defense to keep it in federal. So he must feel like a human hockey puck right now. Now, the claim that defense has made over and over is that Michael DeWitt is fraudulently joined, and this latest filing from Team Buster says that none of their arguments have proven this. Their first argument is that there is no law in the Fourth Circuit that allows for special treatment in First Amendment cases. They also state that the case that defense used to support their argument was from a different district and that under Fourth Circuit law, the burden is on defense, and any legal uncertainties, things that are not clearly defined by law, would have to be resolved in the plaintiff's favor. This fight is becoming so tiresome, and I wonder if Team Buster will end up actually on the losing end if they win this fight for venue. My reason being, what's left of the Murdaugh reputation in Hampton is not what it once was. As far as I know, Michael DeWitt is a good guy, well-liked in the community. And I understand it's not a popularity contest, but I truly wonder if facing off before a Hampton jury that you're not going to find more people sympathetic to DeWitt than you will Buster. I mean, unless there's some scenario of Alex still being able to call in favors there or wave some magic wand, I just don't see a jury made up of people who had friends and loved ones wronged by Alex. Now that all the details of Alex's doings are out there, I don't see them being in a big hurry to throw DeWitt under the bus to help make Buster rich. I really don't. Because beyond Alex, I don't know how well-liked Buster is. And as sorry as I've felt for Buster at times, awarding the next generation Richard Alexander Murdaugh with millions of dollars just doesn't sound like a good idea. So I'm not sure the win to stay in Hampton would be a win in the long run. The next issue they find is with another cited case saying that, yeah, the Fourth Circuit has cited this case, but not for what you're citing it for, which kind of feels like splitting hairs. And then they take issue with this two-pronged test that was brought up by defense, and they're saying that Buster doesn't have to satisfy this test for defamation for the same reason, that he only has to satisfy South Carolina law or the U.S. Supreme Court. They mention another cited case saying, yes, the Fourth Circuit adopted the two-pronged test, but it's only been cited one time in South Carolina and only for one principle, which to me isn't the strongest argument. If it was applicable in the Fourth Circuit and used in South Carolina, why couldn't it be used again? But anyway, they point to the South Carolina standard, which when you hear the name is kind of funny because they've been fighting the whole time about adhering only to South Carolina standards. But this standard itself was adopted from New York, and they literally call it the New York Times actual malice standard. But this standard is whether the defendant published the statement knowing it was false or with reckless disregard of whether it was false. So that's the standard that they say is the only standard that Buster has to meet. So let's talk about this. DeWitt, on the documentary, did not make any new claims of any kind. He spoke about what the local rumors were, and none of those rumors were started by him. But secondly, the sentence that they keep putting on him comes up yet again. And the reason they do, because even I have said from the beginning, this statement does sound troublesome. And you'll see that how they lay that out in just a moment. But here's the thing. Reread the first sentence. He said, so we did a story in the Thanksgiving 2015 paper. This was way back a few months after Stephen Smith was killed. This statement, made in the documentary, is not a new statement. He's not claiming this about Buster. He's retelling events from the past. And where was this stuff said? In his local newspaper on Thanksgiving 2015. Now, keeping in mind what was just decided in the Austin Stanley versus Will Folks case in the last update, which, by the way, has become a historical case, since it's, as Judge Bonds called it, the first case dealing with internet defamation in South Carolina. So if they want to accuse DeWitt of acting with recklessness, this has nothing to do with the documentary at all. Shouldn't they be targeting him and the paper from Thanksgiving 2015? Wasn't that the moment that would be publication? And not years later when something that was already put out in Hampton, which, by the way, is Buster's neighborhood and the place where people know him, and that was important in deciding what publication was. So it was put into Hampton via this paper years before, and then it gets repeated on a documentary as a historical retelling of what happened. So if Buster wants it in Hampton so bad, publication was in Hampton back in 2015, not in this documentary. So couldn't publication be placed in Hampton in 2015 and not in this documentary? And wouldn't that make it a separate suit altogether? Just a question at this point. Now, if that angle isn't correct, and if defense can't find a better one, this next argument by plaintiff is a good one. And the very reason why I've always said from the first update on this case that what DeWitt said might be troublesome. They lay out the situation that Stephen's mom was desperate to know how her son was killed. And they're saying by his statement that he had initially published news stories in an attempt to shed light on the question of who did it. He says he intentionally left out the last name because of fears of being sued, even though everyone knew who he was referencing. So they say that by stating how thankful and proud the community was of his acts, that he implies that there was some potential benefit to his actions, that there was some truth to Buster's connection. But the story did no good, and their interpretation of that no charges were brought against Buster despite DeWitt's efforts. And then they asked the question, why would he want to publish a story linking Stephen's death to Buster unless he, DeWitt, believed this to be true? They say it's clear that he was intentionally implying that Buster was connected to Stephen's death and that he, DeWitt, made efforts to bring this theory to the public's attention. And the good points do continue. They say that defense has not shown or argued that Buster will not be able to acquire more evidence through discovery. So, this is just the beginning. There will be depositions taken. There could be subpoenas for specific information. They're saying you can't deny that no evidence will be found. They also say that DeWitt has not come forward with any extrinsic evidence rebutting these allegations. Their third point is that they have not contorted his statements, but rather defense has asked the court to read each statement in a vacuum instead of putting it all together. They go on to cite cases where things like context, innuendo, and words which raise suspicion can also be cause in a suit, and they state that because all of these reasons that DeWitt is not a sham defendant fraudulently joined, but taking his comments as a whole, both what he stated and information that was withheld, for example, information that could have exonerated Buster, that what he did was not merely repeating rumors. And they then conclude by asking the court to grant Buster's motion to remand, to get the case out of federal court and back in Hampton. So these updates have been coming in hot and heavy, so no doubt we'll see some more replies in the coming last weeks of this year, 2024. Now, I will be traveling pretty much the rest of this year, so I probably won't be back with anything much until January. So have a safe and wonderful rest of 2024, and I'll see you next year. Till then, this is Cassidy O'Connell saying stay well and stay tuned.